Welcome, everyone, to the Rock County Circuit Court Judicial Candidate Forum. Thanks to everyone who came tonight, as well as our candidates. The forum is sponsored by the Janesville and Beloit chapters of the League of Women Voters. The League is a national organization whose work is to educate and register voters and to improve elections and government. The Circuit Court primary election will be February 21st. The general election between the top two candidates will be April 3rd. Of course, we urge everyone to vote in these and all elections. The candidates were sent some questions in writing, and we posted the answers to those questions on the Beloit website of the League of Women Voters. It will be on the Janesville site shortly, I understand. Our forum is being recorded tonight, thanks to JATV for doing that, and they will also share this recording with other media in town, in Janesville, as well as Beloit. There is information on when the rebroadcast will be on the League of Women Voters websites, as well as available here tonight. Okay, ready? The format tonight will be in alphabetical order. We will ask the candidates to introduce themselves in 2 minutes each. I will then ask questions that the League has prepared, and we will stagger the start for those questions. Each candidate will have 1 minute then to answer each question. The audience that is here tonight knows that they may submit questions in writing to Kay Dupree from the League. I will let you know that we have 2 crack timekeepers here tonight who will keep us all on time and flowing smoothly. We do have a limited amount of time, and we want to get to as many questions as we can. All right, with that, Todd Daniel, if you would give your introduction, please. 2 minutes.
Thank you. First of all, I'd like to thank the League of Women's Voters for sponsoring this forum and giving us the opportunity to, through the magic of television, meet a lot of the voters and meet members of the community who are going to have the decision that who's going to be the next circuit judge in Rock County. I'd like to use a little bit of my time to comment on the questions that were submitted to us and that we've responded to in writing that's going on their website. I have a website. It's Todd Daniel for Judge, and I've got some expanded answers to those questions. So if you'd want to, take a look at that, I guess I refer this as the Reader's Digest version of my answers, and then they're expanded on that website. So I'd appreciate it if you take a look at that. My campaign is based basically on 3 core principles. One is education, experience, and independence. I graduated from St. Norbert College up in De Pere in '64 with a history major, and I graduated from Marquette University Law School in 1967. I was at the top of my graduating class, and following that, I entered into the military. While I've been practicing, I've done some teaching at the University of Wisconsin practice course. I've done some teaching in the continuing legal education course through the Bar Association. And if those of you can remember Milton College, I taught at Milton College for a couple semesters. My legal experience all takes place here in Rock County, Wisconsin. When I left the military, I came and started practicing in Janesville. July 14th, 1969, I worked for one of the major law firms, Campbell, Brennan, Stile, and Ryan, for a number of years, and then I became a sole practitioner. And since that time, I have and I am very independent. I have, I guess, unquestioned integrity, and I have the temperament it takes to be a circuit court judge.
Thank you, Todd. Mike?
Thank you. I want to thank the League as well. Good evening. I'm Mike Hawkinson. I've lived in Rock County for most of my life. I graduated from Craig High School in 1980, and I went to the University of Wisconsin-Madison and got a history degree. In 1988, I graduated from the University of Wisconsin Law School with honors. The following year, I was a law clerk on the Wisconsin Supreme Court for a year. And then following that, I decided to come back to Janesville and practice law with my mom, who's in the audience, and her law partner at the time, Ted Bidwell. And I came back to Janesville because I wanted to be in court on a regular basis. And I have been in court, and I am in court almost every day. Today, I was in court on 7 cases in front of 4 different judges. I like being in court. I enjoy being in court, and I feel comfortable being in court. During my career, I've represented people in a vast array of different kinds of matters. I did personal injury work. I've represented people in family law matters. I've done guardianships, CHIPS cases, protective placements. I represent people in criminal matters. And since 2001, I've been one of the 4 court-appointed guardians ad litem. And as a guardian ad litem, I have to advocate for what I think is in the best interest of a child or an incompetent person. And to do that, I need to analyze the law, assess the evidence, and then apply the relevant law, and then come to a conclusion as to what I think is best for that client. That's very similar to what a judge does. And I enjoy doing that. I enjoy listening to people, hearing both sides or 3 sides or 4 sides of a story, trying to evaluate what happened. I enjoy doing that, and I think that I would do well as a judge. This is an important election. Listen to us, read our materials, but talk to collateral sources and find out what we're like in court, how we behave, how we treat people, and then you can make a very informed decision. Thank you.
Thanks, Mike. Jack?
Good evening. In 1920, the League of Women Voters was formed with the stated purpose of improving democracy and the ability of citizens to participate in it. So I thank the League for holding this. I came to Janesville in 1978. I've been here since. I graduated from Lawrence University with honors in 1974, and then went to law school at the University of Wisconsin. During that time I've been here, I've conducted the widest range practice of anybody on the panel, the most cases handled of anybody, and the widest number of jury trials in every aspect of the law, criminal, civil. When you hire a doctor to do your heart surgery, you don't hire somebody who's never done heart surgery. You don't hire somebody to invest your money if person's never invested money before. So when you look at the backgrounds and go to the Wisconsin court system computerized network, and you'll see that I've handled first-degree intentional homicide, termination of parental rights trials that have lasted 7 days, civil trials, jury trials. All of these are jury trials in which the court is an important part of the process. Without that, I don't think a person could be able to conduct a trial as a judge as quickly as one might if you've had that experience. I've also had a wide range of community service. I've coached in the Janesville high school system for over 30 years. I've probably had some of your children, some of your grandchildren as student athletes. In that, I've learned how to deal with people. I've learned how to advise people. I've learned how to be compassionate with people. All of those qualities, I believe, are important for a circuit court judge. And I think that when you go around, and I agree, like Mike said, go around, check it out, ask people. Ask people who's represented them in court, who's been effective, who knows the process. Ask them how they conduct themselves. Ask people that I've dealt with in the coaching aspect. Is he honest? Does he treat me fairly? Does he really care about me? And I think you'll find out all those things are true, and I hope that you vote for me when it comes time. Thank you.
Thank you, Jack. Barbara, you're next.
I'm Barbara McCrory, and I bring something to this race that none of the other candidates does, and that's judicial experience. I've been your court commissioner since 1999. I am in court on a daily basis, and I'm the one that's hearing the cases. In fact, the day the nomination papers were due, with the exception of one of the other candidates, every one of them appeared in front of me, and they were calling me Your Honor and asking me to make decisions for them. And I can put that experience to work for Rock County on day one. Just to give you a little bit of my background, I grew up on a dairy farm just west of Fort Atkinson. I worked in the fields, I milked the cows. The family farm has been in my family since 1840, so that place is very important to me. I'm the youngest of 4 children, which is very humbling when you have my 3 older siblings who are overachievers. My parents always instilled in me, you can do anything you want to, as long as you try hard. My dad recently died, and what he always said is his best crop ever raised were his 4 kids. And I kind of wished he could be here to see what I'm doing today. I attended the University of Wisconsin-Madison both for my undergraduate degree and for my law degree. Between the two, I spent a little time working. I spent some time in the legislature, and I worked for the Attorney General as a lobbyist for him. And that's when I started going to law school. And I always felt like I was the Attorney General's kid who went to law school because none of his children did. They all went to medical school, following in their mother's footsteps. So he would always make sure, what time is it? Don't you have to be a class young lady? Get out the door and get to school. I've been, as I said, I've been a part of the judicial system for the last 12 years. In addition to holding hearings, I conduct legal education where I'm teaching judges, court commissioners how to do their things. I think when you're looking at who brings the most experience to this race, I do, because I've been doing this job for the last 12 years.
Thank you, Barbara. Tom, you are next.
Thank you. My name is Tom McDonald, and I'm an attorney in Janesville. And I'll be honest, I'm the candidate who has not appeared in front of the Family Court Commissioner. I do trial work, and I also serve as a guardian ad litem. In addition to the legal work I've done over the last several years, I've also been a member of the Janesville City Council for the last 4 years. And one of the things we do on the Janesville City Council and in many city committees is a lot of quasi-judicial work, which is judicial work by a member of another branch of government, not as a member of the judiciary. Before going to law school and becoming an attorney, I went to UW-Whitewater, got both bachelor's and master's degrees in accounting, and then worked at a large insurance company in Madison in the accounting department. Now, a lot of people have asked, why would someone in his 30s want to be a judge? And that's a good question. The reason I'd like to be a judge is because I would like to continue the community and public service that I've always tried to have in my life and to live by. Since coming back to Janesville and working as an attorney, I have been a member of Habitat for Humanity and built houses around Rock County. I work with ECHO, the Salvation Army, a homeless shelter in Janesville. I'm a member of the Noon Rotary Club, and I'm a volunteer usher at the Janesville Performing Arts Center. As I mentioned earlier, I've also been on the Janesville City Council for the last 4 years. But the City Council and that legislative branch of government is a lot of volunteer time on evenings and weekends. What I would like to do at this point in my career is take that legislative branch experience and that quasi-judicial experience and move that over to the judicial branch of government. And so hopefully on February 21st and then again on April 3rd, the residents of Rock County can support me for judge. Thank you.
Thanks, Tom. Harry, you're last.
All right, thank you. I'd like to thank the League of Women Voters as well for having the opportunity to appear. What we're talking about here is really the definition of to judge, which is simply the process of gathering information to be able to obtain a decision of the facts that have been presented to you. And I think if you look at my record, I have the more expansive knowledge about dealing with those exact issues. I've been on Janesville City Council for 12 years. I was on the Janesville Plan Commission for 8 years. During that time period, I helped plan and build the Janesville Public Library, where we're actually located, the Janesville Police Department, arranged for the Highway 11 bypass coordination with the town of Rock. And I've done the small things as well, such as taking care of a painting of an arrow to change a stoplight turn signal down in Franklin Middle School, as opposed to spending $30,000 to $70,000 on a new stoplight system. It's those type of things that a judge is going to have to use. The decision-making process, the common sense process, and I bring that to the table over that time period. As far as legal experience, I practiced law in Janesville for 23 years, graduating from Marquette Law School in 1988, lifelong resident of Janesville, born in 1962. I'm married to my wife, Connie Cretney-O'Leary, who's also a Janesville resident. We have 2 children. My daughter Katie's a junior down at Bradley University. My son's a freshman at UW-Madison, so I'm learning to be an empty nester at this point in time. But beyond that, I have expansive legal experience. I've had plenty of opportunities, thousands of opportunities to help clients over the last 23 years, whether it's criminal matters in armed burglary trials. I've done it. I've done adoption proceedings. I've done guardianship proceedings. My primary practice for about the last 10 years has been estate law planning and helping the elderly and the young in guardianship, adoption, elder law, and things of that nature. So with all of that being said, I think I bring to the table the common sense element that's necessary for a judge, and the good disposition and the prepared qualities that's necessary for a judge. And I hope you would vote for me on February 21st.
Thank you. Thanks to all the candidates for those introductions. All right, first question is for you, Todd. We'll start with you. And if during tonight, if anyone needs me to repeat a question, I certainly will. First question, do you perceive any areas of concern in the Rock County court system that you would address? And if so, how would you address them?
Okay, I'm sorry. Any areas of?
Let me read it again.
I want to be.
Do you perceive any areas of concern in the Rock County court system that you would address? And if so, how would you address them?
The way the Rock County court system is set up, that we have judicial rotations in a civil branch, a criminal branch, and then a probate branch, and the judges circulate through them. And with the current array of judges that we have, that works out fairly well. We do have situations where specifically we have a judge who gets substituted a lot, and so he's not carrying a full load, and hopefully this election is going to cure that problem. Other than that, I think we operate pretty efficiently and pretty professionally. Thank you.
All right, thank you. Mike?
I don't have any serious concerns about the Rock County court system. I think we're very fortunate to have a good court system here. I do have some concerns how people nationally view the judiciary and the court system. So I think it's important that people continue to feel comfortable about our court system. I guess in terms of making it better, I guess I would like to try to be a little bit more efficient in court, maybe stagger a calendar rather than having 10 cases at 9 o'clock, 10 cases at 10 o'clock, maybe staggering them a little bit so that people and lawyers who they're paying aren't sitting in court all the time. But I'm pretty comfortable. I think we're pretty fortunate, and I just want to maintain the level that we have, because I do have some concerns about what some of the people nationally are concerned about, and we shouldn't come to that point in Rock County. We should continue to feel comfortable with our judiciary and the court system.
Thank you, Mike. Jack?
The concerns that I would have are probably an evolving concern. As we've evolved with technology and other things in the courtroom, you're constantly having to try to come up with ways to deal with these issues. For instance, it used to be that police investigating, they would write reports, and that was what a lawyer would use to prepare. Now, with the advent of video, there's a lot of video introduced into the court system. One of the problems that we have right now is that video is never transcribed for use in terms of examination of clients. So you're given a video, but you have to hire a reporter to do that. Dane County's adopted a rule which says that if you're going to offer a video in court, you have to have a transcript before. Now, I know that sounds like a small concern to many of you, but in terms of the operation of justice, it's an important part. So I'd say that as we continue to evolve, we're going to need to deal with these technological issues. Those would probably be the biggest area of concern that I would have at this point in time.
Thank you, Jack.
And kind of dovetailing off of that, the resources that are available to the courts in order to do their job is always a constant problem. We have the video recording, we have the opportunities to do video conferencing, so when we have someone who is on an emergency detention for a mental commitment, we can video conference with them at the facility where they're at, but it doesn't always work, and that's difficult, and part of it's because of the resources. We have the ability with our computer system to be able to have all our documents scanned in, so we don't have to have people going and hunting down files, and you can just pull it up on the computer, but we don't have the resources to make sure that that gets done. Our system works well. We have a very good group of judges at this point, and I get to sit in with them on the judges' meetings, and I'm also on the bench bar committee, so that we also hear concerns that lawyers have. Always open for ideas and trying to figure out how to make the system work better.
Thank you, Barbara. Tom?
A couple of the concerns that I have with the Rock County court system right now, number one is technology and its use in the courts and its effectiveness in the law, or the law's ability to keep up with that. The other concern with the Rock County court system right now is the number of pro se litigants that we have. Especially in this tough economy, a lot of people struggle and have legal issues. A lot of people can't afford attorneys, and so as a judge, you need to be able to have patience, you need to show people respect, you need to make sure those people get a chance to have their day in court. And when they leave the courtroom, they feel like they've had that opportunity. A lot of that experience I would take from what I've done on the city council, again, going back to that quasi-judicial experience. When we have people come before the council or various city committees, rarely is an attorney involved in that. Now, we have different rules than the judiciary has, but the same principles apply. And we need to make sure that people who are unrepresented still have their day in court and still feel like they were heard. Thank you.
Thank you, Tom. Harry?
Well, being the sixth out of the candidates, then I just can pretty much reiterate some of the things that have already been said. I agree with the comments about the technological needs. I was up in Greene County just the other day, and they have a more advanced or expanded technological capability than what we have here in Rock County. That costs tax dollars, though, and so we have to live within our restraints. But beyond that, the pro se litigants, I also agree with that whole concept. I mean, more and more as an attorney, we're finding individuals that want to try to do things for the least amount of cost, especially in this economic environment. And so as a judge, you're going to be confronted with that on a daily basis. And I think the way you've got to try to get around that is you're probably going to have more pretrial conferences so that you can try to discuss to these individuals what the rules are in the court system and what's going to be expected of them. And I think that that would resolve the problems in that respect to a certain degree. Thank you.
Thanks, Harry. All right, Mike, we'll start with you for question number 2. In light of your work as a practicing attorney and your relationships in the area, if elected, how would you handle conflicts of interest and recusal?
Well, if I had an obvious conflict, like if my former client was before me or my mom brought a case, obviously that's an easy call. I would get out. To me, it's a no-brainer. I think the more difficult questions are whether or not there might be a potential or a perceived conflict of interest. When I'm guardian ad litem, my wife, Carla, used to work at Genesis. And there were times when parents or children were going to Genesis, not seeing my wife. If they were seeing my wife, I was out. I'm not cross-examining my wife on the stand. But I would let everybody know that that was the situation, so that at the end of that hearing, there was no surprises. Oh, I don't want people to say, oh, you just voted this way because your wife was at Genesis. I think we need to be upfront with those issues, raise them to the parties, let them know ahead of time, and if they have some concerns, we can discuss them. And if they're substantial concerns, I don't have a problem getting out. People should feel comfortable with the decision maker being fair.
Jack?
I don't think it's difficult. Section 757.19 talks about when a judge should disqualify himself. Now, in addition to that, there can be situations where there's an appearance of impropriety. My wife is the court liaison for Rock County, setting up mental hearings. Quite honestly, Judge Daly values her work probably as much as anybody in the county. I would not handle a case with my wife involved, even though the statute doesn't proscribe that. I wouldn't do it just because I think their appearance would not be good. Now, those cases are less than 1% of the overall docket in Rock County. I think that as a judge, it's really not difficult. The statute tells you when to disqualify yourself. You have an idea of what looks good and what doesn't look good to the public. And as judiciary, we have to be very conscious of that. Obviously, with what's going on statewide, the concern is, are we independent and are we influenced by conflicts? Being a sole practitioner all these years, I won't have that problem. And as I've indicated, I would handle the situation with my wife in those 1% of the cases by removing myself. I don't think that's a problem either.
Thank you. Barbara?
Just in the course of my job today, I had to go over the Supreme Court rules again. And the importance of those rules are, we want to have a judiciary that is independent and has an appearance of impartiality. And so when we're dealing with these conflicts of interest, we have to be very upfront with them. How I deal with them when I have a former client, even if it's someone that was represented by someone at the Brennan-style firm where I used to work, I will raise the issue. I will say, someone at my law firm represented you. Under the rules, what I have to do is tell you that. I should recuse myself. I'm now going to leave the room. You can talk about it with your attorney, and if you feel comfortable with me hearing the case, that's fine, but you're going to say so on the record, and we'll go forward. I just had to recuse myself today in a case where I wrote to the lawyers. I know these people personally. I'm not going to hear this case. That's how I handle it, because I want to uphold the impartiality and the appearance of anything, and the appearance in making sure that it is proper.
Thank you, Barbara. Tom?
Impartiality is extremely important in the court system, especially with what's been going on statewide and looking at the Supreme Court. And if somebody has a conflict of interest, it's a pretty simple answer. You remove yourself from the case, you recuse yourself, and you allow another judge to handle it. It's very similar to what I've done as an elected official as a member of the Janesville City Council. There are occasions over the last 4 years where someone has come before the city council with an issue, and if I have a conflict, I know I can't vote on that issue. Or if other council members have conflicts, they can't vote on that issue, you step out. You don't participate in that action. And that's the same thing with the judiciary. If you're a judge and you have a conflict, you follow the rules, you recuse yourself when you need to, and the case goes forward with a different judge. Thank you.
Thank you, Tom. Harry, you are next.
All right. With regards to the conflict of interest issues, in the civil branch, I can't envision one being there, but if I had a presence of one, then obviously you recuse yourself. It's already been said. Within the criminal perspective, my brother's a district attorney, David O'Leary. I'm proud of the service he's done for 16 years that the county's voted him there. The Supreme Court has already come out and said that because the government attorney's purpose in life is not to have some financial incentive like you have in civil matters, that there's no conflict of interest just because you have someone that might be related in a government office, as long as they don't appear in front of you in court. The district attorney as a managing attorney hardly ever rarely appears in court. Branch 7's been a civil branch for 11 years. You can ask him, he's probably been in court maybe a handful of times in that time period. If he appears, conflict of interest. If he doesn't appear, there's no conflict of interest if an assistant district attorney is handling a matter, because all we are looking for is the search for truth. Thank you.
Thank you, Harry. And Todd?
Thank you. As Jack pointed out, the conflict of interest rules are governed by statute 757-19, and more importantly, they're governed by Supreme Court Rule 60 point, I wrote it down here, 60.04, and they're quite clear. In addition to these clear rules, there's what's, as has been mentioned up here, there's called the appearance of impropriety or unethical. So it's not just a question of whether there's a technical conflict of interest, but whether or not there's the appearance of a conflict of interest. And there's a couple different ways, and I think Barb pointed out that distinction. What we're not looking at and what hasn't been discussed in the various forums that we're coming to, there's another aspect to this, and it's called the request for substitution of attorneys. Anybody who feels for any reason they want to disqualify a judge and get a new one, you have the right to do that. And what's going to happen is if we have this appearance of of conflict, and it's not going to be addressed, we're going to end up with the same situation we have there now. There's going to be substitutions of attorney.
Thank you,
It's
Todd.
not going to work, excuse me, but thanks.
All right,
Take
Jack,
off my next one.
the third question is for you to start. What is your opinion about specialty courts? For example, drug, OWI, veterans, mental health, etc.
I honestly believe that they're a great idea. This year, I went to a conference in which the whole focus of the conference was specialty courts, their operation. I know my wife was invited to go down to Rockford to talk, to look at their mental health court, which she did, came back with glowing ideas. You know, people's problems many times force them to violate the law, and what we're trying to do as a society is stop the problem. We want to change behavior. And if we can best do that through a specialty court, we should be implementing it. Now, obviously, there's costs involved with those things, and I understand that. But to me, the purpose of the legal system is to get behavior to conform. We don't want people breaking the law. And if people are driven to break the law by mental illness, by drugs and alcohol, then we should be trying to get at the root of the problem. So I'm a big advocate for specialty courts. I think that they've been proven to work nationwide, and I'm hopeful that as Judge Daly, we can continue that work as Judge Daly has done and implement more and more of them. We're about to start a DUI court here pretty soon. Thank you.
Thank you, Jack. Barbara?
And I echo those sentiments. The problems that we see so often in court, or at least that I see, oftentimes the underlying problems are driven by alcohol or other drug abuse. And if you can't address that, nothing's going to change. And so I applaud the work that we've done with the Veterans Court to address the special issues that veterans have, to the drug court to address those needs, and to the new OWI court that's going to start. My hope is that when these programs end, when the people are done and finished working with the drug court or the OWI court, that they also can connect for continuing services, even if it's going to an AA meeting or one of the drug meetings for the Narcotics Anonymous, those sorts of things, so that they can continue on that path. I'd also like to see an integrated court and family court, so that when we're dealing with the CHIPS cases, if their parents are also going through divorce or have custody issues, that we have one judge dealing with those too, so that they're all hearing the same story. So I think the specialty courts are positive.
Thank you, Barbara. Tom, you're up next.
Specialty courts have a proven track record nationwide, and those that we've implemented in Rock County over the years have also worked very well. And as was mentioned previously, we have a new specialty court that's about to start up, and I encourage the use of those courts because we need to stop the problem. And through treatment and help through those courts, often the problem can be stopped. Locking someone up and throwing away the key doesn't necessarily solve the problem, and if we have repeat offenders and repeat violators and the problem doesn't stop, ultimately that costs all of us as taxpayers a lot of money, because it's not free to incarcerate someone. It's not free for people to be a part of the judicial system. So whatever the costs of the specialty courts, those can typically help people and save taxpayer dollars. Thank you.
Thank you, Tom. Harry?
I concur with the comments that have already been made before. The specialty courts serve their purpose. My concern is whether or not we actually stop the revolving door, and that is the objective behind them, but my fear is that there's always going to be another reason, another excuse for why someone violated the law. My parents raised me to know right from wrong, and at some point we have to draw the line and say that you either know right from wrong or you have to suffer the consequences in that regard. So yes, try to treat the problems that may arise, but what's going to be the next problem that comes down the road that's the accusation or the claim as to what caused them to violate the law to begin with. So there has to be some cutoff point where then you say enough is enough, you've had your opportunity, and the punishment, even if it costs the taxpayer's dollar, is going to have to be paid.
Thank you, Harry. Todd, you're next.
Yes, I believe specialty courts serve a purpose, and they are quite effective, especially the drug court has been quite effective. There are a couple of issues that must be dealt with. One is that we have to be careful that we are not requiring people to forfeit many of their constitutional rights that attend them in a criminal proceeding to get into a specialty court. The other concern is that they're kind of county to county and they're county-wide, and I believe that this should be dealt with at the state level, and so that obviously each county has the same. And as a Vietnam veteran, I am definitely in favor of the Veterans Court. I think us Vietnam veterans are kind of, timing ourselves out, but we've got another whole new set of veterans coming from this, what's going on in the Middle East, and I think they're going to be a bigger issue than us Vietnam veterans.
Thank you, Todd. Mike?
I agree with everybody here. Specialty courts are an excellent idea. Not only do they address the underlying problems, but they also provide an opportunity for people to get help when they can't get it on their own. I've had several clients participate in the drug court, and they had serious drug problems. They didn't have any insurance, and they didn't have any money. And if it wasn't for the drug court, they would just be continually in and out of jail. And the only chance that they really had was to participate in the drug court. And that I've had clients have their lives changed by the drug court. So I believe that if we give people an opportunity to change, and Harry's somewhat right, people have to take responsibility. People have to decide whether or not they're going to change. We can't just put them in the program. But if we give them that opportunity, it can make a huge, huge difference. And those people don't come back, both in the criminal cases and also in the family law areas. If we can deal with those underlying problems, we'll have a better citizenry and we'll have less people in court.
Thank you, Mike. Next question. You're up first for this, Barb. Please describe one instance in which you faced an ethical dilemma and how you resolved it.
I like to try to think that I haven't had too many of those, because of the way my parents taught me, and that is you do what is right and you call it out when it happens. As far as the work that I do, I know that there are those fine lines that I don't cross in terms of communications with people outside of court, in making sure that people are aware of what's going on. Also making sure that I am separating myself from people so that there isn't that appearance. I went so far one time as my husband and I were grocery shopping, and I said, "You need to go down that aisle." And he said, "Why?" I said, "Well, because there's a litigant who's been appearing in front of me on a regular basis down there, and I don't want people saying that I'm with that person or that I've seen that person outside of court." So I try to be very careful about that. And I'll leave it at that.
Thank you, Barbara. Tom, now to you.
Well, with an ethical dilemma, I'm going to have to go back to that city council experience. And there's occasions arise where, on the one hand, as an elected official in a legislative branch of government, you're elected by the people to decide issues and to vote. And on the other hand, if you have a conflict of interest, obviously you have to step out and not participate. But when you have that perceived conflict of interest, that's when you really run into the dilemma, because a perceived conflict of interest may suggest to the public you shouldn't vote, but on the other hand, especially in a legislative branch of government, if there's going to be a close vote and your vote may be the deciding vote one way or the other, or if you don't show up, something may not happen or may happen as it should not have, that's going to be a difficult situation as well. What you do in those situations is you have to weigh the issues and you have to make a decision as to what's going to be in the best interest of the community and those people you represent. Thank you.
Thank you, Tom. Harry, you are up next.
I'm glad I had a few moments to think about it. I guess from my legal perspective, I've had clients come in and want to do a co-divorce process that wouldn't develop very well. And you tell them up front that if that's the case, they both are going to have to go out and get new attorneys, because I've already been helping them as their single attorney. In the criminal process, I have a brother that's an officer on the Janesville Police Department. He's been there for many years. I had a client come in to me at least on one occasion on criminal matters or things of this nature, and sometimes simple traffic matters, that ask me if I can help them out with it. And I look on the citation and I say, "Oh, it's Officer O'Leary." And I go, "Well, I think I've got a conflict with the fact that my brother." So we talk about the conflict of interest. I recuse myself as their attorney, telling him I really can't represent them and not come and call my brother as a witness in those incidents. So that's where you do it. You just recuse yourself, or you try to step aside if that be the case.
Thank you, Harry. Todd, to you.
Generally, in the circumstances that I find myself in, the only ethical dilemmas I generally deal with have to do, again, with conflicts where you've represented someone in a family matter, and 15 years down the road, one of the kids shows up, or the person that was on the other side of you 15 years ago shows up. And my view has always been, I'm scrupulous when it comes to conflict. I'm scrupulous when it comes to ethics. And if there's any hint or any suspicion of any type of a conflict situation, I've got enough clients and I've got enough contacts that I'm not going to prejudice my reputation for handling a case that I shouldn't handle. And I just, I refer them on down the road and try to avoid those situations the best I can.
Thank you, Todd. Mike.
Well, I just,
Want you first?
I would just I try to treat people the way I'd want to be treated. That's the way my parents raised me. So, for instance, sometimes in a criminal case, I'll get the case, I'll start reading the reports, or I'll do an investigation, and I find out that an important witness was a prior client of mine. I call up my client and say, "You know what, I got a problem. I can't handle this case because this important witness is somebody I've represented." Then I notify the court, tell the court the situation, because I don't want any impropriety to be thought that there might be there. There have been a few occasions where I've represented two people in one case. What I'm thinking of is grandparent visitation right. Two grandparents came to me. I said, "I can represent you both, but But you need to understand that if you guys don't agree at some point, then I can't represent either one of you. So I try to be upfront if there's a potential ethical problem so that they can make a decision and then they know the consequences in case something horrible happens.
Thank you, Mike. Jack, to you.
Thank you. This question highlights why experience is so important in doing a judicial job. Years ago, I had a first-degree intentional murder case in Beloit. I was trying before Judge Dahlberg, God rest his soul. I was in the middle of the case, and I anticipated there might be a problem with my client. I had to research the issue of what happens if your client gets on the stand and says something differently than he's told you before. The case was controlled by a case called Whiteside versus Nix. The process, and you didn't want to interrupt him while he's testifying because it's going to basically sell him down the river. So the process that I learned was you basically, at the point that there becomes a non-truth before the court, you simply have to say, is there anything further you'd like to tell the court? Now, if I had anticipated that in advance, if I had researched that question, I think my client's interests would have been greater jeopardized than they were. So that's why when we talk about experience in the courtroom, that's the way you get that experience. And as a judge, that's how you learn it, and that's why you'll be an effective judge. Thank you.
Thank you. Next question. We'll start with you, Tom, for this one. Within the limits of the statutes, what factors will you consider in assigning criminal sentences?
Well, within the limits of the statutes, and there are guidelines set forth. The judges also discuss guidelines on a county-by-county basis. But sentencing is something that is going to happen after a criminal hearing, typically or always in felony cases. And what's going to happen is usually there's going to be an order for an investigation by the judge. And in that investigation, then information is going to come to light, and that information will assist in determining an appropriate sentence within the guidelines. And I can say at this point, nope, that's it. Thanks.
Thank you, Tom.
You're welcome.
Harry?
With regards to criminal processes, in many instances, there's going to be a dispositional report that's going to be prepared that's going to give you some insight into that individual's background, their family history. As we mentioned before, maybe they've had a history of alcohol abuse or drug abuse or something of this nature. So you're going to have some guidelines, some kind of basis that you try to understand what this person's background is. But if it's a repeat offense, if it's an offense of severity that's much more severe in the community, a sexual assault, a murder, or a bank robbery, or things of this nature, obviously you're taking it much more serious because the judge is going to have to evaluate as to how do you punish this person, how do you help this person maybe get back on the right track, but how do you protect society, and how do you deter society from someone else out there committing a similar offense. So the judge has to juggle all of those issues under the guidelines and with the overall guideline of keeping the community safe, and that's what I would do.
Thank you. Todd, you're up.
Yes, sentencing guidelines are very specifically set out in case law in the statutes. In other words, these are the things you must consider, and it's 1, 2, 3, and you have to go down the line. They're called the clarity standards. And in the sentencing procedure, the judge actually has to take out the book and go through each one of those factors and explain how that factor entered into the decision that the judge is making in putting together what the sentence is going to be. So it's almost kind of like a recipe book. It tells you exactly what you have to consider, tells you exactly how you have to consider those things in a totality, and you have to actually explain on the record how each of those factors went into making your decision. And if you miss any of those, you get to do it again. So it's pretty basic. Thank you.
Thank you, Todd. Mike?
Now, the case law does outline important things that we need to consider when in sentencing. I think the clarity standards are basically you look at the character of the defendant, the severity of the offense, and the need to protect the public. And those are the big three things that you look at. And in terms of personally, I don't want this behavior to happen again. So I look at what I call specific deterrence in terms of what am I going to do to make sure that this particular person before me doesn't do this again. Do they need treatment? Do they need to go to a specialty court, drug court, to prevent this from happening? Or do they need to sit in jail? Or is a fine appropriate? Have they learned their lesson? Second thing is general deterrent. I want the general public to know that this is unacceptable. So if they get an idea, if I behave like this is going to happen to me, and I don't want that to happen. And then I also think you have to take into account how that's impacted, how the offense has impacted the victims, and what kind of impression it's made on them.
Thank you, Mike. Jack?
Thank you. It is very clear. I think the question was, what's the criteria? And the criteria is set forth in State versus Cleary and State versus 2. And basically, you do have to do a balancing act, and that's why they call it judging. You have to balance the needs of the defendant versus the requirements of society, the need to protect the public. And normally, when you hear that somebody's going to prison, the judge will tell you that although probation is the presumed result, and it is, it's the presumed result, unless it becomes so clear that one of these other balancing factors require a person to be incarcerated. And Todd's right. The judge has to go on the record. He has to make those statements and findings. And it's those findings then that one can argue, that's what we argue in court. Well, we believe that the public can be protected by these various alternatives. So when the question is what's the criteria, it is not difficult. The criteria is well established and it's there. And lawyers, who are in the courtroom every day, argue it every single day. And it's a balancing factor, and that's why they call it a judge, because the judge has to balance those factors. Thank you.
Thank you, Jack. Barbara?
You've heard what the lawyers have had to say about what the law is. The issue then becomes, who as a voting public do you trust to listen to those things and exercise the discretion within the background? And that's what I've been doing for the last 12 years. It becomes the issues of protecting the public, the deterrent effect. You look at the pre-sentence reports, you see what the person's done, and then you have to weigh all those factors. One of the issues as well that I haven't heard anyone talk about that I think also has to go into that balancing act when you're listening to it is also the victim impact. That's another thing that's going to be part of it. They have a role and a right to be at that table and at least making a statement. And the court also has to be able to balance that. So that's the issue for a voting public. Which one of us do you trust to be able to listen to those facts, to be able to apply that law, and provide an appropriate sentence?
What are your views on whether the Rock County Circuit Court deals effectively with racial and gender bias?
I don't see and by that I mean as far as the racial goes, I don't see it. Gender bias, as an attorney that's practiced divorce matters and things of this nature, I've seen it, in my opinion, as an attorney. You render opinions, and I think I've seen it on divorce matters, depending on what gender you might have as to the perspectives they go. It's pretty much common knowledge that if I have a client coming into my court for divorce matters and it's a female and she wants maintenance, you're pretty much telling them that Rock County is very conservative. You're not going to win those arguments in many instances in Rock County for any length of time. So that's perhaps one example I see, maybe a gender bias. But as far as an overall in the criminal perspective or other issues like that, I don't see a racial bias within our county.
Thank you, Harry. Todd?
Well, we're getting to the nut of the case here. I agree with Harry. I don't believe any of our judges are displaying any racial bias, any social status bias, or anything like that. We do have an issue of gender bias in, particularly one of our courts. And again, hopefully that is going to be corrected by this election, and that's the practical fact. It's an empirical fact. All you have to do is go look at the court records, and one of the leading judges in the state of Wisconsin for being substituted against is the incumbent in Branch 7, and he's finishing up his term, and hopefully that situation is being corrected. That's the fact.
Thank you, Todd. Mike?
I personally don't see any gender or racial bias, but I will admit that maybe my perspective is a little different than some people, especially of a different racial background. But, when I'm in front of the judges, I don't see that. I certainly don't treat my clients differently. My parents taught me to treat people as to who they are, not their gender, not their racial background, not even their occupation. We should all treat each other equally. So I don't see that happening. I don't treat my clients like that. I would be appalled if it did happen, because that's just not right. We're all equal in the eyes of the government here, in the eyes of the court system. We should all be treated fairly. Thank you.
Thank you. Jack?
Thank you. I took the question not to mean as it relates to the judiciary. I don't see any of that. I will tell you that just 2 weeks ago, I tried a first-degree intentional homicide case. My client was black, and as I normally do in a situation like that, I address it with the jury right on. And I basically told him, it's 50 years ago, we had the basis of the book, The Help. So to think that in 50 years, we've eliminated all of that, I think is foolish. And so the question would be of the jurors, okay, can you really put it aside? Is there any part of it that's going to influence your decision? Because if it is, I'm going to ask you to tell me that, and I'm going to strike you from the jury or ask the judge to. So while it's all of our goal to move it out of our life, my goodness, President Obama would be an illustration of that. To think it's gone from the judicial system entirely, I think would be a mistake. I think it's a goal we have to continue to work for. Thank you.
Thanks, Jack.
I agree with Jack that it is a goal that we have to continue to strive for, and I will give you an example of a way that I might have to deal with it, especially with the idea of a jury trial. My husband represented a lesbian in a sexual assault case, and so he asked the judge if he could do a private, survey, no names, written paper, about whether or not people could give her a fair trial. And he was really shocked at some of the responses he got back. And so I think if we want to address those issues, that is one way as a judge you can address those issues so that you can look at it. From the standpoint of how I handle it in my court, you come in and you're a parent, and that's it. And I don't look at you as to whether you're better because you're a mother or you're a father, or if you're the father, you should be paying support, and if you're the mother, you shouldn't. I try to look at what's best for your children, and that's how I look at it. You're a parent, not your sex, but what's your parenthood. So that's how I look at it there.
Thank you, Barbara. Tom?
One of the reasons that I've been hosting listening sessions around the county is to get out and hear from residents who are outside the system, who aren't attorneys, who aren't people who are in court every day, but maybe who are only there once as a juror, once as a party in a case, because I'd like to hear from people what their perspective is on our system. And this is something that I have heard from a few people. This is one of the concerns, and I'm sure that's why we have this question tonight. And it's something that, in terms of the judicial system itself, what I would do in courtroom as a judge is, first of all, myself, treat everyone fairly, treat everyone with respect. Age, gender, religion, creed, none of that matters. Everyone is treated equally. But the other thing we have to do is address it with jurors. In the trial work I've done, we do a lot of personal injury civil matters, and we need to address that with juries, especially when we have minority clients, because we need to make sure everyone's treated fairly, judge and jury. Thank you.
Thank you, Tom. All right, question 7. Back to you, Todd. Child placement in divorce cases is often difficult. Please speak to the concerns some have for fathers and their custodial rights. Assembly Bill 54, which is yet to be considered, would expect to equalize child placement to the highest degree possible. Your comments and thoughts.
This goes back to basically gender bias, and hopefully at the end we're going to have an opportunity to make some further comments on some of the things that we've just discussed. Right now, the law is that the children are to spend the most amount of time that can practically be given in their interest. We have a certain segment of our population making this a political issue, and that's the fact. And we can sit up here and dance around all we want. The fact of the matter is we have political issues that are interfering with child custody, they're interfering in the divorce process, and that law adds absolutely nothing to the current law. The judge is to divide placement in a way that each parent gets the most placement that they can practically handle in the child's interest. And to start with a 50-50 does not get you to an end that is in the interest of the kids.
Thank you, Todd. Mike?
Well, I think every child has a right to have a healthy relationship with both of their parents. That's the bottom line. And currently, the law is that we have to try to maximize the amount of time the child can spend with each parent. I don't think we need a 50-50. I think we have to look at what's best for the child. And there are some times when 50-50 isn't best. I deal with this on a regular basis. That's part of what a guardian ad litem does. I have to come to court and tell the court, you know what, I've talked with the parties, I've talked with secondary sources, and this is what I think is best for the child. I deal with this on a daily basis. And it is important. I'm very lucky. I have two great parents. I have great relationship with them, both. I work with my mom. I'm very close with my dad. And I want every child to have that same opportunity. It's extremely important. But to automatically say 50-50 is not good for the child. There are certain times when it's just not healthy for the child just to start off with 50-50. You have to look at that child's situation. You have to look at the parent's situation and try to craft the best response for that child.
Thanks, Mike. Jack?
I would echo those comments. I would tell you what makes the family law area the most difficult is we have an adversary process. That's our court system. We have somebody suing somebody, the state suing a defendant, a plaintiff suing a defendant. What we add into the family law area that makes it difficult is we add in the children. And so I do agree that the law does say we have to maximize the free time available for both parties with their children. But when we superimpose a legislative mandate, making certain assumptions that perhaps somebody's being deprived, I think the casualty in that can be the children. I know a good number of us deal with this on a daily basis. And the other thing that's happened is they've introduced an economic element to this placement. Place money, child support's determined on a number of overnights. That's another complicating factor working against sometimes the best interest of children. So those are problems, those are concerns, but I don't think the law adds a lot there, the new law. Thank you.
Thank you, Jack. Barbara?
This is an issue that is near and dear to my heart because while all of these gentlemen can say they'll do it, they do it here and there, I do it every single day. And I'm the person that has to make the decision when the parents can't. And I always tell them, all right, I understand you each have your position, but I need to take a step back and view this as your child would view this. And that is a responsibility that I take very, very seriously because as Mike said, children are entitled to a healthy relationship with their parents. The problem that we have is that parents sometimes can't have that healthy relationship. And that's what we have to be looking for. We made substantial changes to the law about 5 or 6 years ago, and those changes have really worked their way into the system, where we're seeing much more shared placement than we saw when I first started out in practice, and I think that's positive. But we can't take away the judge's discretion to look at what's best for the child. I wish I had a magic wand and I could make parents get along, but unfortunately you have those cases when they don't, and when they don't get along, you can't put the child in the middle of that.
Thank you, Barbara. Tom?
Ultimately, in these kind of matters, it's about what is in the best interest of the child. And without echoing a lot of what's already been said, because I think it's been pretty well covered, the one thing I would add is that as a judge, it's not our responsibility or it's not a judge's responsibility to comment on a law. The judge is there to interpret, apply, enforce the law as it is. And so whatever the law is, as a judge, that's what you're going to have to go by. And so at this point, judges have flexibility to craft what's in the best interest of the child. Whether the new law would help or not, well, the judge is going to have to go with whatever the law is, and the judge is going to have to be able to work with whatever the law is. Thank you.
Thank you. Harry?
Well, Barb has the luxury of being able to discuss the issue without having to worry about making a livelihood. It's not as simple as that with regards to placement issues when you're actually practicing the law of having to go out there and have clients and dealing with divorce issues. I've lost clients because they come in and are adamant that they want to have single custody of their child. You try to express to them that it's not, the likelihood of that is not very high, because we are looking at the best interests of the child, that we are trying to look at trying to maximize the quality time of the parents. And if that parent's going to work at that evening but insists on having that child evening, what's the point if that child is with an aunt or a grandma or a relative other than the mother who may be readily available, just so we can maximize the 50-50 placement? That's the kind of juggling you have to do as an attorney, is that's what you have to try to help your clients understand. That's what I'd, as a judge, help them try to understand, that it's the best interest of the child that overrules the parents. Thank you.
Thank you, Harry. Mike, next question. You're up first. Who are your judicial role models and why?
We had this question last night, so, yeah, I said Judge Rothy. You know, he treated everybody fairly, he was prepared, and, you know, he had a certain way of carrying himself that you knew he was a judge. Now, I think we're very lucky. All the judges on the bench have great qualities that I would probably adopt, but if I was going to pick one person, it would be Judge John Rothy.
Thanks, Jack.
I think I started the eulogy for Judge Rothy last night. The question was posed, and, you know, we do have a lot of good judges. Judge Rothy, if you knew him as a litigator, was a hard-driving, aggressive, very insistent litigator. And when he took the bench, and quite honestly, I kind of view myself in the same way. And when he took the bench, he adopted a process by which he was always prepared. He was experienced in dealing with issues, and I would agree. When you went before him, you truly felt that you were being listened to, your opinions were being considered, and he made a decision based on the evidence and the law. And when you walked out of the courtroom, you felt like, well, you know, I was either successful and great for me, or I was unsuccessful, but I really felt like the issues were considered. That's a judge I think one would want to emulate, and that's a judge that if you could be like him, when in the end, when it's all said and done, you'd feel very good about yourself. So I too would say Judge Rothy, but we've had a lot of good ones, and I've appeared in front of a lot of good ones.
Thanks you, Jack. Barbara.
And I'm going to continue on the Judge Rothy bandwagon. And that's because he really was, as they have said, the sort of judge that you'd like to appear in front of, because he did his independent work, and he was prepared. And that's how I like to think I also am. In fact, I did have an attorney say to me, he goes, "You're prepared, you've read the stuff, and you're at court on time. What more could we want?" And I do take some of that from Judge Rothy. I also have the pleasure of working up in Jefferson County as well with Judge Irwin up there. And she is also a very well-prepared judge. And I've learned some things from her in terms of scheduling and keeping your court moving. And one of the things I really admire about Judge Irwin is that she has got one of the highest affirmance rates in the Court of Appeals. When her cases get appealed, they rarely get overturned. And I think that's also something that's good, because she explains what she's doing so that people understand it, number one, and number two, the Court of Appeals also understands it. So that's also an important thing.
Tom.
Well, I would actually emulate several judges, basically try to take the good qualities out of those that I've seen. Unfortunately, I did not have the pleasure of working with either Judges Dahlberg or Farnham, but I've heard many good things about them, and they would both be right at the top of the list, it sounds like, had I had the opportunity to be in front of them. But any judge that I've been in front of, I would try to take the best qualities, because ultimately, as a judge, you need to respect the people that come into your court. You need to listen. You need to make sure both sides have an opportunity to tell their story, that at the end of the day, parties and attorneys feel like they've been respected, like they've had an opportunity to be heard, they've had their day in court. And as a judge, those qualities are what's important, and so that's what I would be pulling from other judges. In addition, some well-placed humor in the courtroom to lighten things up once in a while, because it otherwise can be a very formal and intimidating thing. Thank you.
Thank you, Tom. Harry.
Judge Dahlberg is the one I was going to mention. I've been practicing since 1988, and I recall Judge Dahlberg when he was down in the Beloit courthouse that we had down there. In particular, he always would be willing to talk to even the youngest attorneys. I was just cutting my teeth in a banked armed robbery criminal matter, and we had a jury trial going on, and he calls the attorneys in there, and he just talked to you as if you were his best friend for 25 years. I remember that to this day. And he practiced many, many years, and he had a very interesting listening style where you thought he was going to fall over and off of his chair because he was asleep. But his eyes were closed and everything. But he always was paying attention. He always knew what was going on. But he would have you guessing whether he was awake in the courtroom or not. But I really respected that man, and I miss him. So.
Thank you. Todd?
I guess last night I didn't understand the question, and maybe I don't understand the question again tonight. But it wasn't who I'm going to emulate or whatever. It was just like, who was a judge? And the only thing you can say about Judge Dahlberg was he was a judge. I mean, there was no question about it. He had that manner. He had the presence. That was a judge. And the rest of us are kind of like judges, but he's the judge. He was actually the longest serving. He was the oldest judge in the state. He stayed at it right to the bitter end. He had a great sense of humor. As a criminal defense attorney, I really didn't like one of his mannerisms, that he let the jury really know, and it's all the little subtle stuff. Because if he thought you were winning, all your questions were overruled. And if he thought you were getting killed, Katie barred the door. But Judge Dahlberg was a judge, and if I could even be half a Judge Dahlberg, in size at least anyway, I'd be happy. There's a picture of him at the court. I know him over time. There's a picture at the courthouse. You got to go see it.
Thanks, Todd.
Yeah, I'm sorry.
Okay, last question. Jack, you're up first. Why should voters support you rather than your opponents?
I will tell you why. I've had the widest range of experience. There are people in this panel that have not tried a criminal case or handled a criminal case. There are people that have not tried a civil case or handled a civil case. There are and so I've done all those things. I've been dealing with those problems on a daily basis. I've been in the courtroom. I'm in the courtroom every single day, the large majority of the day. I've had to prepare cases. I've had to anticipate rulings. I've had to anticipate what I need to do in certain situations, just as a judge needs to do. I've dealt with the people in the community, check around, ask people, what do they think of me as a coach? What do they think of me as an instructor at the schools? What do you think of me when I've gone and I've spoken to your club or agency? And I think you'll see that I'm a person of my word, I'm a person of integrity, and I'm a person who cares about the community and cares about the people in it. I have had the good fortune of coaching many people who are now successful people in this community. I'm proud of that, and I love my association with them. Thank you.
Thank you, Jack. Barbara?
As I started out, I will reiterate it again. I have judicial experience. I've been doing this for 12 years. A lot of the same work that I do is the same work that a circuit court judge will do. I hear contested cases on a daily basis where people will come in, they will tell me the issues, they will tell me the facts, and then I apply the law to those facts and give them a decision. They may not like it, but when they walk out of my courtroom, they know they've had their say, and they know that I have listened to what they've had to say. I also have to do written decisions, and I do them within the guidelines of 30 days that I have to as a court commissioner. Those are the times when I have to take a case under advisement, look at the law a little bit closely, do a little bit of independent research, go over my notes, take the facts, apply the law, give them a decision. I also know how to manage a calendar. I've been doing that, keeping cases moving so that they don't get lost. And furthermore, I've taken that trade, and I'm also now doing judicial education, where I'm working with judges around the state and trying to help them improve what their courtroom and their practices.
Thank you, Barbara. Tom?
This right here is the big question, and ultimately in this case, it's a very difficult question because, to be quite honest, in my opinion, every single person who's running for judge is qualified to be a judge. And so this is going to be up to you as the voter and the individual to determine what you think is important. Is having an older attorney important or a younger attorney? Is having someone who's practiced in certain areas or other areas important? That's going to decide your vote. Do you want someone who's got experience in another branch of government, as well as coming into the judiciary? How much trial experience, or is trial experience important to you? All of those things are going to be important. What about someone's education? Everyone's got legal degrees and the legal background. My degree, I've got that accounting experience and that strong financial background. The city council experience I've got, that legislative branch of government, and then character. You'll have to figure that out as well. Thank you.
Thank you, Tom. Harry?
Jack talks about his vast trial experience. Of course, he's going to have more than me. He's going to be 60 years old. I'm 50 this year. But I've practiced for 23 years. I've handled thousands of cases. I've dealt with criminal matters, adoption proceedings, guardianship proceedings, and a wide variety. I have that experience in the legal world. I'm capable of being able to sit up on the bench and make decisions that are appropriate based on the facts that are presented to me. As far as community involvement, I think I'm second to none among these candidates in community involvement. 12 years on the Janesville City Council, 8 years on the Plan Commission. I was on the board of directors for Forward Janesville. I'm involved in my church at St. William's in a variety of functions, and I'm currently serving on the Rock County Zoning Board of Adjustments and Appeals, a quasi-judicial body which leads me to have to render judicial decisions relating to people's property, their lives, and their property. So I think I have a broad spectrum of abilities and skills that I could bring to the bench and be a very effective, fair, and justice. Thank you.
Thank you. Todd?
It's my belief that both in my professional life and history and in my community involvement, my experience is the deepest and it is the widest. And I have tried cases in every court. I've handled 6 murder cases, 1 murder verdict down the line. Besides my professional experience, I served on the school board for 10 years. I was on chairman of the various committees. I finished my career on the school board as the president of the school board, and I have this pun that was a very educational experience. You're supposed to laugh. Oh, I know, that's a bad joke if I gotta tell them. She used my time. The other thing, I'm a Vietnam veteran, and that was probably the most maturing experience in my life. I am independent, I am honest. People are gonna say that I'm too independent and too honest, but I will continue to be honest. I will address the facts as the facts are, and I'll never tell you a lie.
Thanks, Todd. Mike, you're last.
Wow. Well, I think you should look at my experience. I've handled a number of different cases. I've been guardian ad litem. I've had to evaluate evidence, apply the relevant law, so I've done that. But I think probably more than anything, I like to be in court. That's where I want to be. It's not just a judge. It's not just a job, I guess I should say. My kids tell me, man, when you talk about court, you're passionate about it. This is where you want to be. I came here after I graduated from law school and I clerked at the Supreme Court because I wanted to be in court. I'm in court on a regular basis. I feel at home. I love to listen to other viewpoints. That's part of my history major. I know that there are more than 1 or 2 stories, and I love to hear those stories and try to figure out what happened, what the truth is. If you elect me, I hope that you will be able to say, when I come into my courtroom, he was prepared. He knew what was going on, both in terms of substantive law and procedure. He listened to me. He treated me fairly. He treated everybody fairly. And he gave me a decision that I understand, and I understand the reasons for him giving that decision. Thank you.
Thank you. Well, that ends our forum tonight. Thanks to everyone who came out. We appreciate that. And thanks, of course, to the candidates.
Thank you.
Good night.